Federal versus State Court Systems and Jurisdictions. Now we're going to discuss the differences between federal courts and state courts. We're going to start now with the state court systems and then move on through an overview of the differences between the state court system and the federal court system before we get into an in-depth discussion of California courts. The California state courts, as in other state courts, have three separate levels: the trial court or superior court level, the California Court of Appeals level, which is above that, and the California Supreme Court level. This mirrors the federal court system, where there are also three levels: the lowest level, the Court of Appeals, and the Supreme Court level. Other states have similar ways of breaking up their court system into three levels, even though they may call them by different names. There's one California Supreme Court. It is the highest court for California, and it has 7 judges who sit on the court level. The California Court of Appeals, there are 6 different courts of appeals in California, which has 105 judges. And the California Superior Court, or the trial court, there are actually 58 of them. There's one for each county. And there are well over 2,000 judges and magistrates who are employed in those court systems. So let's talk about the trial courts first. What happens there? The trial courts is where you actually see the most action. That's why there are so many of them. The job of the trial court itself is to decide the cases by weighing evidence and applying relevant law to relevant facts. This is actually the only level of courts where you're going to get an actual trial, per se, where the parties get to bring in evidence in front of an arbiter, in front of a fact finder. The fact finder gets to look at the evidence and decide whether or not the law and then apply the law and decide who to weigh in favor of. When you get to the other levels of courts, you're actually reviewing the work of the trial court, but the judge does not go back and look at these particular pieces of facts again. The evidence are not going to be displayed again. The witnesses are not going to come in again for the most part. We are pretty much doing all of that called fact-finding within the trial court level. So as our previous slide showed us, the Superior Court of California is where this all takes place. You can have criminal or civil cases in the Superior Court, and they can be jury trials or en banc trials. An en banc trial is just a fancy way of saying a bench trial, which means instead of having a jury present, you can just have the judge decide your case. There are different reasons why you may want a jury trial or a trial just in front of a judge, but for the most part, it's up to the parties to decide which one they want because they're going to have the right to both. Also, as I mentioned, this is where witnesses and other evidence are going to come into play. So these are the most fun courts to watch, to go in and see what's going on, because you get to see the entire factual storyline play out of what actually happened in the cases. Another thing that happens in the trial courts is that we have the small claims courts and specialty courts. We used to have something called municipal courts, but Prop 220 actually unified the municipal courts at the Superior Court level, so now we have them all together in one, and you'll find it all at the Superior Court level. That's for the state of California. Alameda County Superior Court has 2 branches in Oakland. I have no idea where you all are sitting tonight, but supposing we're sitting in Laney College, then we would be in the state of California, in the county of Alameda, and these would be our 2 local courthouses. The Renee C. Davidson Courthouse is actually around the corner from Laney College at 1225 Fallon Street. They do both civil and criminal cases, and they also have a juvenile calendar there. If you go down to about 6th and Washington, you'll find the Wiley Manuel Courthouse. The majority of this is a traffic court. It is connected to a prison there, a jail there rather, and there is traffic hearings that go on there as well. By the way, both of these courts are open to the public. It is your right as a citizen to walk into one of these courts. You'll have to go through the metal detector, but you can go in and sit in on almost any case that's going on. You don't have to present who you are or anything. You can just go and sit in the back and observe and just say, if the judge asks you, you can just say that you're here to observe the proceedings as a student or someone who's interested in the system. And judges generally welcome that. I've seen them be very open to that. There are very few situations where the court would not allow people in. There are some cases which have to be closed to the public. Usually those have to do with the cases in which you have a young minor who is involved and testifying, and so they want to keep that person's identity protected. But for the most part, you can walk in and find out what's going on the calendar. You can ask the bailiff when you walk in what's going on, and they can probably direct you to an active department which is hearing cases for that day. The California Court of Appeals is your next court when you don't like the decision that has happened at the trial court level. Basically, what an appeal is you're going to rehear a court case that's already been decided. Basically, you're asking a judge to look over the work that the prior judge has done and make a determination that that lower court judge at the trial court level made an error. They messed up, they made a mistake, they interpreted the law incorrectly, and so therefore, higher judge, I need you to look at this case and figure out what they did wrong so that you can overturn the fact that I lost in the lower case. When you're at the appeals level, you no longer have plaintiff and defendant or prosecution and defense anymore. The names change. Now they are the appellant and the respondent. It doesn't matter which party you were in the first place. For example, the plaintiff doesn't automatically become the appellant. Whoever is the one who's seeking the appeal, which is the party usually that lost, is going to be the one who's the appellant. So say you have a situation where a defendant loses a case and they want to appeal because they think that that lower judge did not get it right. Then in the next case, in the appeals level, they will be the appellant and the plaintiff will be the respondent. The Superior Court also has an appellate section which does some of the appeals in California for small claims and for limited civil jurisdiction, which is when you're suing in civil court for under $25,000. We also have a misdemeanor department within the Superior Court which does hear appeals as well. What the appeals court will do, however, is they'll decide whether or not the judge made an error in interpreting that law. If they decide the judge did make an error, they can reverse the decision and remand it to the lower court. They will not hear all of that evidence again. The only time all of that evidence is going to be heard again is if the Court of Appeal decides to remand to the trial court level and they tell the trial court, do it over again. Start all over again. This is called reviewing the case de novo. Start all over again like you never heard this case, bring all evidence again, and do it over. But that would not be done at the appeals level. The Supreme Court level in the state is similar to the Court of Appeals in that if you don't like the answer that the appeals court gave you, you can then appeal to the highest court in the state of California, and that is the California Supreme Court. It works the same way. So if you don't like what happened at the trial court level, you can appeal and become the appellant at the appeals court level. Then if you don't like what happened at the appeals court level, you have one more chance, and you can appeal to the California Supreme Court. The only difference is the appeals at the Supreme Court level get to be chosen by the judges who hear them. They don't have to hear all of the cases. They can decide which ones they want to take and which ones they don't want to take. They have different reasons for why they might take up a case. One reason would be if the courts of appeal disagree. We mentioned how there are 6 different courts of appeal in California. So if Court of Appeal in the 1st district is going to make a decision, and the Court of Appeal in the 3rd district hears a similar case, and those 2 decisions don't make sense together, they disagree for whatever reason, then the California Supreme Court may hear that case on appeal just to say once and for all what the rule is. The higher the court it is, all the lower courts have to listen to what that court said. So if a Court of Appeal makes a ruling, then the trial courts have to listen to the rule that the Court of Appeal made. So the California Supreme Court, being the highest court, if they can make a rule, then that rule will filter down not only to all of the appellate courts in California, but then down to the trial court level with the superior courts as well. Another reason they would want to hear a case is if it's an important or a novel legal question. That just means it's something that really hasn't come up before, and really they're not quite sure what to do with it or what the answer would be, and that might be something they want to look at. Or they find it to be important for some reason, either politically, academically. Another reason that they might hear it is if the Court of Appeals did not have authority to decide the case in the first place. And we'll talk a little bit about jurisdiction in a while, and that's going to tell us about when a court would have an authority to hear a case, and sometimes they just don't. They do get most of their cases from the appellate courts. However, if it is a death penalty case and somebody is sentenced in a death penalty case, the defendant can appeal from the superior court level, skip over the appellate court level, and appeal directly to the California Supreme Court. This is what the California Supreme Court looks like if you're ever in the neighborhood to drop in and see it. Again, you can walk in there and actually take a tour of the building. This is a map. This is a very fuzzy map of the California Judicial Branch. I'll have this cleaned up for the next time we talk about this. If you'd like to, please go to courts.ca.gov. It's a great resource to see the different information about the courts in California. The top link here will actually give you the link to this particular map. What this is an overview of the California Judicial Branch, and you'll see that the courts is only one of the 4 circles that is attached onto this. We're going to be talking about the other 3 circles in depth as well later on in the course, but I just want you to be aware of the fact that in state court systems, there's much more than goes on in the courtroom. There are a lot of different things that go on and a lot of different facets of the judicial branch. And so we're going to be talking about all of those different things, and just understand that they all work in Congress together in order to create the judicial branch that we know.